All right, hey guys, lecture, 3, pages 9, 10, 11, and 12. A lot of this is going to sound familiar, and then a little bit of this will be new, all right? So we talk about life, liberty, property, and the due process of law, right? So this first whole chunk, 1, property rights versus public welfare, I'm just going to kind of simplify for you, all right? There's this concept of eminent domain. Now, essentially what the Constitution says is that eminent domain means that the government can take private property if it gives just compensation, right? So if the federal government or the state government takes a person's property, they have to give them a fair market value. Now, you can already see where this is controversial, all right? Generally what it means, though, like, they can't take it because they just like it. They take it because there is some public welfare or public good or public use that land is going to be. So I think we have an example of eminent domain right here at Pyramid and McCarran, right, where they're widening the road for public use, and therefore all those houses on the east side of the Pyramid Highway right there are purchased, and those people, the government is invoking eminent domain to take that property to widen the road, all right? Now you can imagine there's some absolute controversy, all right? Because maybe some people don't want to give up their property, even if it is for the public use, right? So you can see the conflict in it, all right? But again, we have this freedom versus order balance that is definitely going to anger people at times, or maybe even make people happy at times, all right? This idea of eminent domain. Okay, now let's move into this next part on the bottom of page 9, all right? We have these concepts, right? We know that the 5th and the 14th Amendment have due process clauses, correct? All right, so government is prohibited from denying you life, liberty, or property without due process of law. So they have to follow certain procedures, and they can deny you those things, right? Okay, so procedural due process and substantive due process, right? Procedural due process is the way in which they deny you life, liberty, and property. The procedures themselves must be fair, and we're going to see some examples of these in a few minutes, okay? So procedural due process is this idea that the process in which the federal government denies you life, liberty, and property, or government denies you life, liberty, and property, have to be fair, all right? Now, the second type of due process is the substantive due process. It's not just enough that they use fair procedures to deny you life, liberty, and property. The law itself must be fair, all right? So the idea here is that laws have to be fair in and of themselves. They have to be just in and of themselves. One of the things that I like to look at substantive due process is the outcome of a law just? If the outcome of a law is just and fair, then it doesn't violate substantive due process. All right? And so generally one of the ways you look at, you can see at the bottom of D there, all right? Procedural, the method, and substantive is the outcome just, all right? And you can categorize those as either procedural or substantive. Try that and we'll go over it in class, all right? But generally, whenever you're looking at, if you're asking, is a law fair, you're looking at substantive due process. When you're looking at the procedure in which they deny you life, liberty, and property, you're looking at procedural due process, okay? All right. Now, let's move over into this whole idea of arrest, questioning, and imprisonments, all right? So arrests or seizures can be conducted, right, with a warrant or probable cause. They can search, all right, and seize property. They don't need a warrant if they're in hot pursuit or when probable cause exists, right? If they see, you driving erratically, they can pull you over because they think there's probable cause that you are drunk. Or if they see you fleeing a scene of a crime, they can do that, right, in pursuit. Now, searches, all right, can be conducted with a warrant. A warrant has to be have probable cause, right? Now, warrants are generally specific. I know for you guys that have dads and moms that are in the law enforcement, there's a lot of real detail to this. But the idea is generally search warrants are supposed to be very specific. The idea behind that is that if they're specific, that means that law officials, have something in mind that they're looking for. They have reason to be looking at your stuff, right? Now this contrasts with these British writs of assistance, which were general search warrants, where basically the British used them, to kick in any door at any time that they wanted, just to look for stuff to see if you were breaking laws, right? When we were colonists, all right? Now, look at some of these things without a warrant under these sections. if probable cause exists, right, the automobile exception, if police have reason to believe that you are armed and dangerous, they can do it, all right? If they're arresting you for a lawful arrest for committing a crime, they can seize your stuff, all right? If you give them consent, all right? Now, if the evidence is in plain view, they can seize it, all right? And again, you have the Board of Potawatomi versus Earls in 2002, which again, they can drug test people, students, for extracurricular activities. There's no probable cause. They can just randomly do it, right? That's technically a search into your chemistry of your blood, right? Okay. Now, they can wiretap if a warrant has been issued. Now, we have this FISA court in 1978. FISA courts essentially allow our intelligence agencies to go to judges at a moment's notice and give probable cause, all right, and to be allowed to conduct that surveillance with wiretapping, that kind of thing, right? It was speeding the process up, but still allowing, law enforcement officials to go in front of a judge and say, look, here's our probable cause, all right? Now, look at this, the exclusionary rule. What it does is it says illegally obtained evidence may not be used in court. So if police officers, police officials, law enforcement officials get evidence illegally by beating you, by seizing it incorrectly, it'll be thrown out. Now, this was established, this exclusionary rule. It's not clear in the Constitution, but Mapp v. Ohio basically creates this for state law issues, and then US v. Weeks, or Weeks v. US, applied it to federal issues, all right? Illegally obtained evidence cannot be used against you, all right, or used in court, all right? Now, the idea here is that, we want police officers following procedural due process when they arrest you. Now, critics of that are going to say, if police don't follow these things perfectly, a perfectly guilty human being that clearly did something wrong may get their case thrown out because the evidence wasn't perfectly obtained. This is, again, the balance in a civil society. It's quite often difficult to please both sides in that case. We want bad guys arrested, but we also want innocent people proven innocent, right? We don't want, evidence gathered in ways that are definitely defying law, that are unjust, right? That kind of thing. So the idea behind the exclusionary rule is it keeps police officers kind of on their toes to follow a certain set of procedure, in a fair way, right? Whereas it also sometimes can get innocent people off if they don't dot their T's, cross their I's, and follow these things perfectly. All right, now there's a couple of things that the exclusionary rule doesn't apply to. All right, inevitable discovery. What that means is if they pull you over for a ticket and they see a dead body in the back, they don't need to go get a warrant. They have a dead body. They can stop you right there. They can seize this. If they see 10 pounds of cocaine in the back of your car, they just see it there, or illegal weapons or something illegal. If it's in inevitably they would discover it. Or if they're conducting a search warrant that says, okay, we got to go to the back room of the house, but while they're going down the hall, they look to their left to an open door and there's a dead body. They don't need another warrant. That's not going to be illegally obtained evidence, right? Okay. Now the other thing is good faith assumption. The idea that police officers generally assume that a warrant is valid, meaning when they go to search for certain things, they can do that, all right? They can use that warrant, all right? All right. Now, just in case there's some mistake by a police officer. And again, if we look at the Patriot Act as far as search and seizure goes, right? The Patriot Act gave our intelligence agencies a much broader ability to spy on Americans. Again, ideally with probable cause, ideally, following procedural due process. However, speed is of the utmost, and sometimes secrecy is the utmost. And so, we have this balance between giving them enough power to stop bad guys from doing a 9/11 thing, but at the same time protecting us and our security, right? Freedom versus order. And the other idea here is that even though we saw the NSA with the Snowden leaks and all that, where they were spying, basically gathering, without probable cause, without warrants, right? But again, here's this thing is, freedom versus order. Like, we'll call the federal government to task if they allow another 9/11 to happen, but at the same time, we're angry that they're doing certain things that may be violating our rights. And so that's the rub, that's the contradiction, that's the difficulty, right? Okay, now let's move over to page 11 here. If you look at self-incrimination, the Fifth Amendment, right? You're innocent until proven guilty. You don't have to testify against yourself, all right? And that's the Fifth Amendment, right? Now, police questioning. Forced questioning is prohibited, all right? Now, you have Miranda v. Arizona in 1966, which basically says police officers have to tell you have the right to remain silent, you have the right to a counsel, so then you can answer questions once you get a lawyer, right? Just to make sure they're following procedural due process. All right, and again, Miranda, that's a huge case. The fact that they have to tell you that you have certain rights because certain people aren't aware of their rights. All right, here we go, another thing, habeas corpus. Habeas corpus is simply that they have to, if they detain you, they have to charge you with a crime in a certain amount of time or let you go. The idea behind this is they're going to bring you in front of a judge and formally charge you with something. If they don't have the evidence to formally charge you with something, they have to release you. You know, this protects you against unlawful detainment, unlawful seizure, right? Okay. Now again, it can be suspended in cases of rebellion or invasion, right? Which we see, and that's key, I think, for you to understand. Right, two other things. No ex post facto laws, no bills of attainder. Right, we've looked at those a couple times this year. Those are denied. Right, Congress cannot pass ex post facto laws, nor can they pass bills of attainder. All right, okay. Now, let's look at these kind of rights of an accused person if you are accused of a crime. Right, Gideon v. Wainwright and Johnson v. Zerp say that you have the right to a counsel, and if you can't afford one, the government will give you one. All right, that's Gideon v. Wainwright and Johnson v. Zerps. Gideon establishes it. It's probably the one that's going to be on the test. However, they could tell you Johnson and talk about right to a counsel. All right. Again, it's not clearly written in the Constitution, but they're assuming that that's a right, maybe out of the Ninth Amendment, right, that you have. All right. Gideon v. Wainwright, the right to counsel. Okay. Now, again, the Eighth Amendment protects you against excessive fine and bail. All right. So basically, the gravity of the crime needs to match the amount of bail. So if you steal a candy bar, they can't give you $1 million bail, right, or fine. Right? It's got to match the crime you do. All right. Now, the other thing also about the Eighth Amendment is it protects against cruel and unusual punishment. All right. And the idea there is that the punishment must be fit or proportionate to the crime. All right. Now, the death penalty has been ruled as not cruel nor unusual. You know, we have challenges that right now, not necessarily cruel and unusual, but the fairness of the death penalty, you know, according to race. All right. But this idea that the Eighth Amendment does not allow torture, does not allow cruel and unusual punishment. That's why we've also progressed from, say, firing squads and hangings to lethal injection or the gas chambers is ideally to be a way in which people who are charged and convicted with murder die quickly, right? Okay. Now you also have the right to a speedy trial, right? Now your grand jury, right? Remember what a grand jury does versus a petite jury. There's the grand jury basically says you've been charged with the crime. Here's the evidence. Is there enough to go to trial? All right. This kind of just simply says they're figuring out if there's enough to go to trial or not. All right. And then you have the petite trial that actually says guilty or innocence, right? Now, again, the Fifth Amendment has not been nationalized or incorporated. The grand jury requirement has not been incorporated to the states. So some states have it, some states don't, but the federal government does have it. So if you're in the district court, you're going to get a grand jury first, right, to see if there's enough evidence to go to trial. All right. Now, again, you have the trial by jury, speedy and public trial. All right, which again, the speedy and public trial is the idea that it's transparent, the process is transparent, it's not behind secret, and closed doors. And the other thing, speedy, is it ideally pushes you forward so you're not sitting in jail for 2 years before they get you a trial, right? Like that would be unlawful. All right, witnesses, you have the right to bring witnesses on your behalf. You have the right to confront the witnesses that are accusing you of something. All right, and then finally, this idea of double jeopardy. You cannot be charged with tried for the same criminal act. Now, here's the deal. If they announce you innocent, they can't recharge you for that specific crime. However, if there is a mistrial where they couldn't come up with a verdict, they can charge you again. If you violate state law, they just declare you innocent at the state, they can still charge you and try you at the federal level, all right, if there's a concurrent jurisdiction, to bring back an older word, all right? All right, so, hey, really quickly, eminent domain about property, procedural and substantive due process, all right? Arrests, questionings, and imprisonment, right? Fourth Amendment protects against illegal search and seizures, all right? We bumped into a couple things. When they can search, what the exclusionary rule is, all right? That you have the right, you cannot be forced to question unless you have a lawyer there with you. Then you can answer questions, right? You have the right to a counsel, Gideon v. Wainwright, no excessive bail or fines, no cruel and unusual punishment, both 8th Amendment. All right, speedy and public trial, the grand jury, trial by jury, witnesses, and then finally double jeopardy. All right? Okay, that was it. If you have any questions, let me know, all right? Almost break, you guys. Good job. Okay, bye.